Judge, the sentencing's ready, if you want to grab that. Mr. Horn.
I got two lawyers that showed up on time today. That's good. We're getting better. People against Nicholas J. Horn, 25T704225. Mr. Horn, your name? You got to start your video, sir. I need two of these. Good morning, Mr. Ambrose. Your appearance?
Yes, Ronald Ambrose appearing on behalf of Mr. Horn.
Good morning,
All
Ron.
right,
Nicholas Horn.
All right, so I was not here, but your client pled guilty, it appears, to, he was charged with assault, resistant, obstructing officer. And he pled to attempt, which is a 1 year. The 2 year was dismissed. And then he also pled to disorderly person, is set forth in count 2. He was referred for a pre-sentence report. Have you had the chance to review the report with your client? Are there any material additions, corrections, or deletions?
I have reviewed it with Mr. Horn. No additions, corrections, or deletions to the report.
All right. Is there anything that you would like to say on his behalf?
Your Honor, it looks like it's a fair recommendation. I would ask the court to adopt it.
Mr. Horn, anything you would like to say?
Yes, Your Honor. I understand by the looks of my record that my prior behalfs in this courtroom, not just this courtroom, but other courtrooms, that doesn't look very well on me. But I have been doing a lot better, Your Honor. These actions of mine on this offense, they don't define me. I've been doing a lot better. I've been clean and sober, Your Honor. The day of this incident was the day that my grandmother had died, and I made a couple wrong decisions and took a couple steps back, Your Honor, and I'm just looking to take those steps forward to get back to where I was, not to be who I used to be.
You're 28?
Yes, Your Honor. I've been doing the best that I can. I lost my parents at a very young age, and it's been tough, and I've been fighting through it. But I'm not trying to make excuses for any of my actions, and I know my actions have consequences, and I'm here to accept that.
Who do you live with?
I live with my adopted mom, my legal guardian, my legal mother. She adopted me at the age of 9 years old, Your Honor.
I mean, you're just getting yourself in more and more trouble. I'm really sorry about your grandmother, but you cannot keep doing this. I mean, you're attempting to kick a police officer. You drank alcohol again. I would have thought you would have stopped after these other two. I'm just telling you, you get another one in your life, it's a felony, and your life as you know it will be over. Counsel, have you seen his AA recovery? His AA NA steps?
I have not.
Well, I need to see him. Mr. Horn, let me see your AA sheets. You're going to have to hold them up to the camera.
Your Honor, I wasn't given a sheet to fill out. I've been going to the Alamo Club on Dix in Council in Lincoln Park, and I also have been going online just because it's hard for me to get around, being that I don't have a license, and I have 4 kids that I care for, and I'm present in their lives every single day, Your Honor. So it's a little complicated for me to just be able to get around, but I have been attending as much as I can.
Well, that's not going to be good enough. I'm telling you, that's not going to be good enough. You were ordered by Judge Hessen to go 3 times per week, right?
Yes, Your Honor.
Why haven't you been going 3 times a week? Why don't you have any proof of this?
I apologize for not having the proof of evidence of it, sir, but I promise you I have been going. All I have is my word at the moment on that, Your Honor. I apologize.
You've been testing
Yes, Your Honor.
and you're still on the sober link.
Yes, Your Honor.
Is there anything else anybody wants to say here? Mr. Ambrose, anything else?
No, thank you.
Your Honor, if I may.
Yeah.
I was supposed to test this morning, but I had to be here on Zoom with you, so I wasn't able to make it, and I do have to work today. I was wondering if there was any way I can get some type of leeway to be able to go tomorrow morning.
Wait a minute. What time does you go? You tested DNA?
Yes, Your Honor.
They open at 6:30 in the morning.
I understand,
Why
but
didn't
for me
you-
to
why-
get there,
Go
get
ahead.
there at 7, I didn't have a way, Your Honor. I had no way to be able to get there. I had no way to be able to get home post that. It's hard for me to get around. My kids are here. It's hard for me to just get around. I can't Uber with my kids. I understand Uber is an option, and also financially, it's not a big option for me at the moment. I pay a lot in child support, and I don't make a lot of money.
Well, the child support, there are guidelines in accordance with how much money you make. So if your income went down, go back and talk to the friend of the court, referee, or judge, or what have you.
I'm waiting on them to get back to me on a court date, Your Honor.
All right. So I don't want to be negative, but right now I'm just telling you, I don't think you're going to make it through probation. I'm going to give you a chance. If you don't, there's going to be a consequence to pay. You're looking at a 1-year misdemeanor. 15 months probation. These terms will run concurrent. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you have to notify probation. You have to report as directed. No alcohol. You're not to purchase, possess, or consume alcohol or illegal controlled substances. You're not to purchase, possess, or consume marijuana either. Kratom poppy seeds and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. Now, I'm going to order chemical testing, PBTs, and ETGs. I'll go along with this somewhat reluctantly bi-weekly for 4 months. If you're clean, I'll make it monthly. Defendant to remain on SoberLink device until May 1. You're to remain on the SoberLink device until May 1. You are, and again, all of these terms are concurrent. You are to attend personal counseling. You're to attend personal counseling as recommended, and that will be at the Guidance Center. And you're to attend AANA 3 times a week until you're in outpatient treatment. And I want you to listen to me very carefully. I won't make you go in person in light of what you said. But on each date that you watch, you need to identify the date. You need to identify what was discussed. I don't want any names in there. And you need to prepare that and have the date, what was discussed, and where the meeting was on a sheet of paper. And you have to have some 3 or 4 sentences as to what was discussed. That will satisfy that. You're going to go to AANA at least 3 times a week until you're in outpatient treatment. I'm going to order outpatient treatment. Once you get in outpatient treatment, you no longer have to attend AA or NA. Now, you did not, you were in custody for a day, is that true? Or 2 days?
2 days.
All right. I just feel like you need to wake up. You need to wake up.
I was awake, Your Honor, and I lost my way that day, and I took a couple steps back, and I'm ready to jump forward to back to where I was. I was doing great. I was on a good path, a sober path. I was saving money. I was with my kids. I had my family, and these actions, I've lost all of that, Your Honor. I have already lost everything close to me, and I'm just trying to work on getting everything back in order.
All right, well, here's what I'm doing. You're to remain on the sober link, as I said, until May 1. You're going to go to AANA or any 12-step recovery program 3 times a week until you're in outpatient. Once you get in outpatient, you can stop going to AANA. You remain on the sober link device, as I said, until May 1. I'm going to order 7 days jail credit, 2 serve 5, and I'll let you serve those by way of court work program. You're going to do 5 days on the court work program. There's a $35 a day charge for that, bringing the total to $175. Do you understand that?
Yes, Your Honor.
All right. Now, in terms of fines and costs, I'm going to go pretty light on the one case I'm talking about on the disorderly. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment. That's 3 1/4 or 90 days. All your fines and common costs, like screening fee, will go on the attempt R&O. So that's a $60 screening fee on that case, fines 100 on that case, cost 200 on that case, 75 victims' rights fee, $50 justice assessment. That's 485. Probation fees are 300 for 785. And then you have 175 in court costs. Everything included amounts to $960 or 1 year in jail if you violate. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Your total here, including everything, is $1,285. Can you pay all of that today? And by the way, you may be eligible for early discharge if you get everything done and stay out of trouble. Okay?
Yes, Your
After
Honor.
half the time. How much can you pay today?
I don't have any money, Your Honor.
Well, you're gonna have to set up a payment plan. Tell me how much.
Today, I don't. I have $2 to my name right now, Your Honor.
You're misunderstanding. Just tell me how much you can pay weekly going forward.
I get paid bi-weekly, and honestly, Your Honor, it's probably going to take me the whole entire 15 months to pay off that $1,200.
You're going to have to listen to me. I need you to tell me how much you think you can afford bi-weekly. When is your next? When do you get paid next?
The 4th of April.
You pay $25 bi-weekly. Beginning April the 7th, you're going to pay that on the disorderly, and then you're going to pay after fines and costs on the attempt R&O. You're going to pay on the R&O after you pay the disorderly, and all money is due. All money on these cases is due because you're not going to get there only paying $50 by week or $50 a month. So all money is due.
Your Honor, if I may, I said $125.
Are you sure you can pay $125?
Bi-weekly, yeah. I'll figure it out and I can make it happen.
All right, okay. $125 bi-weekly beginning April the 7th on the disorderly, and then you're going to pay $125 after fines costs paid on the other case, the attempt R&O. I wish you well. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Mr. Ambrose, anything else, sir?
No, I appreciate your indulgence, Your Honor.
Have a good day. Mr. Horn, you seem like a nice kid. You got to act like one. Don't act like a criminal anymore, okay?
Yes, Your Honor. Thank you.
Good luck. I wish you well. Thanks, Mr. Ambrose. Have a good day.
You too. Take care.
Both of you. Jacob Dusseau. Jacob Anthony Dusseau, 25M4978849. All right. Mr. Dusseau. Trooper Bear, your name?
Hey, good morning, Your Honor. Trooper Byer, Michigan State Police.
Mr. Dusseau, there you go. Your name, sir?
Jacob Dusseau.
All right, I don't know if you, he lives in Riverview. I don't have a traffic record here, Lisa. Can you print one out down here? Did you look at his traffic record, Trooper?
I did, Your Honor. He has nothing previous on his record.
Okay, no, don't worry about it, Lisa. Do you want to offer him something impeding?
Yeah, I'm fine with that.
You want to plead to that, Mr. Dusseau?
Impeding, what would impeding,
0
end me with?
points. It's going to result in a fine. That's it. It's not going to go on
Okay,
your
yeah,
record.
that's perfect.
All right, to that charge, responsible or not responsible?
Responsible.
All right, I'm going to accept the plea, dismiss the speeding. Slow down though, please. 150 is your total. Can you pay that today?
Yes, I should be able to pay that today, Your Honor.
You go on 33court.com if you want to save yourself a trip over here, all right?
Okay, thank you so much.
Trooper, do you have any others or is that it?
No, Your Honor, just the one today.
What time was that scheduled? 9?
9 o'clock, yep.
Not bad. All right, you're out in 5 minutes. Have a good day.
All right.
Thank you.
You too,
Good
Your
luck,
Honor. Thank
Mr.
you.
Dusseau.
Have a great
Thank
day,
you.
Your Honor.
2. Tyarius Bryant, 24B7163541.
Good morning, Your Honor. Max Manugian, P76341, appearing on behalf of Tyarius Bryant, Your Honor. He has sent me a screenshot showing that he's in the waiting room. I don't see him in here right now.
All right, we'll get him in here. Give us a second, okay?
There he is.
All right, Mr. Bryant, sir, I need you to state your name, start your video, please. There you go. Your name?
Tyarius Bryant.
All right, Mr. Manugian.
Your Honor, today's date and time set for a probable cause conference. Mr. Bryant understands his right to a preliminary examination, his right to hold that examination within 21 days of his arraignment. However, at this time, he wishes to waive that right and have this case bound over to the circuit court.
Is that what you want to do, sir?
Yes, Your Honor.
As your lawyer said, you do have the right to a preliminary exam on these charges. Actually, you're charged with, I believe, just one count. Let me just double check that, please. Yes, one count of stealing or retaining without consent a financial transaction device. That's a 4-year felony. You have the right to an exam. At the exam, the people would have to show that the crime was committed and that you were the one who probably committed the crime. If you waive your right to an exam, you will automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, Your Honor.
Anybody force you to give up your right to a preliminary exam?
No, Your Honor.
All right, I'm going to accept the waiver. I find the waiver has been made voluntarily and understandingly. You're bound over for further proceedings to the Criminal Justice Center, April 8th at 9. April 8th at 9. Bond is $3,000 personal. And that was personal, right? Lisa, Judge Kirsten didn't write cash or anything. Is it personal?
Yes, Your Honor.
Yeah, personal.
All right, so that bond is continued. April 8th will be your court date. You still have a pretrial here, I believe, sir. So you're going to have to stay right there. Why didn't you should have come in for your misdemeanor. Let me just double check something here. Can you give me that file or give me the, yeah, you have a pretrial. So April, I don't mean to keep you, Mr. Manugian. I'm going to set that for April the 8th. And that will be arraignment on the information, but I do want you to understand your client also has here another charge, a pretrial, it says for B&E. So I don't know, it must just be a misdemeanor. So it is just a
I'm
misdemeanor.
appointed on the felony case, so I
understand. I just wanted you to be aware, and you need to stay there, Mr. Bryant. We're going to set you up with a court-appointed lawyer, okay?
Okay.
He has Mr. Carmen on that case.
Okay, yes, Mr. Carmen. So you'll be talking to Mr. Carmen. I just want you to be aware you have that pending and don't leave until you resolve it. Detective, anything else on this case from you? Your name?
No, good morning, Your Honor. Crystal Toulas, Brownstown Police Department. No, Your Honor, thank you.
Have a good day. Thank you very much. And good luck, Mr. Bryant, but stay here. Thank you. Thanks, Mr. Manugian.
thank you, Your Honor.
Who is, Mr. Nasser? Good morning, your name?
Yes, good morning, Your Honor, and to your staff. May it please this most honorable court, Mohammed Nasser, P74485, appearing on behalf and with Mr. Ross Young, who appears via the jail. Mr. Young, please state your full name for the record.
That's not Mr. Young. We'll have to switch him.
That is not Mr. Young.
Mr.
No,
Burke,
it's not.
can you switch for Mr. Young? Yes, can you ask them to switch you?
Yeah, we want Mr. Young, Ross Young. Ms. Holloway, your name? Are you on this case? No, you're not, are you? Who's the special prosecutor on this case?
It's APA Davidoff. I will be standing in for her.
Okay, your appearance?
Nora Alloway on behalf of the people, standing in for APA Davidoff.
All right, and Detective Morrison. Good morning.
Good morning, sir. Detective Sergeant Morrison, Brownstown Police.
Yeah, we need Ross Young in here, Deputy, please. Ross Young. All right, so I hope you have Ms. Davidoff's calendar because I don't need to do this on a Tuesday.
Well,
So
Judge,
you go ahead.
So sorry, Judge. What we're going to be requesting is a competency evaluation, please.
Okay. All right. Let me get Mr. Young in here and we'll handle this. So you're gonna have to do the order on this. So we'll have to put this probably 7-8 weeks out, Lisa. I mean, I think that's about how long it's taking them. Good morning, Mr. Young. Your name, sir? You have to unmute if you can, please. Yeah, it's over on that wall there somewhere. I don't know how. The pros and cons of technology, right? I mean, there we go.
Good morning.
Young, your name?
Good morning, Judge. Ross Young.
All right, so we're going to set this for a competency exam, and we are going to set this, Lisa, in about 7-8 weeks for a review hearing.
May 13th at 9 o'clock.
May 13th at 9 o'clock. So that'll likely be Judge Hessen's handling that then at that time, Mr. Nasser. Mr. Young, I'm ordering a competency exam. We'll prepare the paperwork. Bond is otherwise continued. Anything else, Mr. Nasser?
Judge, if I may address bond, please.
Okay.
Judge, currently, undeniably, the allegation of CSC first is a very serious and significant allegation. Certainly, I take nothing away from that. However, Judge, my client is now 31 years of age, has not one but 3 jobs. He's also in school for mortuary sciences. He works in a funeral home. He's got 3 jobs, no record. Gainfully, like I said, he was gainfully employed. He has the opportunity to get that job back. More importantly, Judge, in speaking with his family, he has a third-party custodian, namely his sister, and he's going to reside in Detroit during the pendency of this particular matter. Our desire, Judge, is also to have him independently evaluated by Dr. Gerald Shiner. Certainly, that will be expedited by having him on bond. So I'm asking this court to consider a reduction. Undeniably, this allegation occurred in this great city. My client has no reason to be in the city. We have no objection to a GPS tether to ensure that he does not return. I'm asking you to consider a reduction to $75,000, 10% GPS tether, house arrest other than work and or medical.
Ms. Holloway, what can you tell me? Judge Hessen set this. I don't know anything about it.
Yes, Your Honor. The people would oppose any modification of bond. This case does involve a significant amount of charges, including criminal sexual conduct in the first degree, kidnapping, assault with a dangerous weapon, and a felony firearm. So the allegations do involve the criminal sexual conduct involving a firearm. We believe that these are incredibly dangerous allegations, and in support of the victim, who is very scared, we would oppose any modification.
And Judge, if I can respond very briefly.
Go ahead, sure.
My only response to that would be, Judge, there's a presumption of innocence, and a fact that the individual does not have a criminal record at the age of 31 should speak volumes. He also has retained counsel. People don't retain me if they're going to run, Judge. I would concur with the prosecutor's sentiment in terms of, based upon the allegations, danger to the community. However, there are conditions or a set of conditions that can circumvent that, namely a GPS tether and house arrest, with the exception of medical and work. He doesn't have to return to the city at all, Judge. And if he does, he's going to be locked up and no possibility of bond. But however, I believe $500,000 is excessive. And I believe that $75,000 to $100,000 with 10% GPS tether is more than sufficient, but not greater than necessary in order to ensure safety to the community.
Nice job. Nice argument, Mr. Nasser. Unfortunately, I'm not going to go along with it. I'm going to continue the bond. We'll see what the competency report says. May the 13th at 9 a.m. Have a good day. Thank you, gentlemen. Bond
Always
is
a pleasure,
continued.
Judge.
Thank you.
You.
And ladies, too. Thank you.
Judge Livingston County just logged in.
Okay, Ms. Bates, I'm going to need you on that one, please. Justin Edward Horn, 24W7035751. Good morning, sir. Your name?
Justin Horn.
Good morning, Ms. Bates.
And good morning, Your Honor. Melanie Bates, P76080, appearing on behalf of Justin Horn, who is present.
And Detective Cerna, I believe that you are on this one. Is that accurate, or is it? No, it's Detective Despremi. I need your name, sir. All right. Detective Davis, your name.
Detective Davis, Woodhaven PD, but Detective Sergeant Vespremi just stepped out of the office. I assume
that's fine. I just need you to convey the, the date that we're going to give him for the exam. Okay. What date do we want to do? This is Mr. Mohammed's case, right? So we have to set it on a Tuesday.
Yes.
What do you got for me?
He said whatever date is fine with him. I think that we really just need to know how long the federal custody, how long they need to provide him.
Do you have any idea, Lisa?
No, but it took me 4 days and multiple emails just to get the approval for Zoom.
How about if I do it in 3 weeks?
Okay, the 15th.
Is that good?
Yep, 10:30.
We'll do it the 15th, Ms. Bates, at 10:30. Either that or I. Good.
I have an exam scheduled at 11 in Lincoln Park.
Where?
In Lincoln Park on the 15th. So I can
tell you what, we'll make it at 1. How's that?
That'll work.
Is that good, Lisa? For me?
Yeah. Yes, that works.
April 15th at 1 o'clock. I wish you well, sir. We'll see you here. Thanks, Ms. Bates. Have a good day. And we'll see everybody on the 15th. Thank you. Thanks, Detective. Okay. People against Rachel Christina Pigeon, 23W832-682. Mr. Shemke, your name again?
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client.
All right, Ms. Dusseau.
Emily Dusseau.
Ms. Pigeon, your name?
Rachel Pigeon.
And I have Detective Cerna there. Raise your right hand again, Ms. Dusseau. I realize I swore you in before. You solemnly swear or affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes, Your Honor.
Okay, go ahead.
So I have her sober link report here. Her last test that she submitted to was April 23rd of 2024 at 7:02 p.m. Or I'm not sure what she's contesting because it goes on that every test. So April 23rd of 2024, 11 p.m. she didn't submit to the test. 7 a.m. on the 24th, 11 a.m. on the 24th, 3 p.m. on the 24th. I could go on.
Yeah, you need to do that though. Go ahead.
Okay.
She missed all those.
Yep, the 24th at 3 p.m. April 24th at 7 p.m.
Actually, can I ask you a question?
Yeah.
Did she fail to submit the sober link blows? It's 7 a.m., 11 a.m., 3 p.m., 7 p.m., and 11 p.m. on April 24th.
Yes,
And the same times that she failed to submit on April 25th,
yes,
and the 26th,
yes,
and the 27th,
yes,
and the 28th,
yes,
and the 29th.
yes,
Do you have evidence that she tested positive at on-site for alcohol on April 24th of 24?
yes, I have the lab report right here.
All right, any questions of her, Mr. Shemke?
No, Your Honor.
Does your client wish to testify or remain silent?
I would advise you to remain silent. It's a technical violation. The allegations are fairly black and white, and I was going to respectfully request some leniency, but it's her right to speak, so I'm advising she remain silent.
Do you want to testify, ma'am, or do you wish to remain silent?
Remain silent.
Okay, well, first of all, there's sufficient evidence here to establish by preponderance of the evidence that you violated your probationary status in 8 different ways. You failed to submit to a SoberLink device on April 23 of 24. You tested positive for alcohol April 24 of 24, and then as set forth in counts 3 through 8, you failed to submit to SoberLink blows at 7 a.m., 11 a.m., 3 p.m., 7 p.m., and 11 p.m. on April 24th, is set forth in count 3. On April 25th is set forth in count 4. On April 26th is set forth in count 5. April 27th is set forth in count 6. April 28th is set forth in count 7, and failed to submit on the 29th at those specified times. So I'm going to find you guilty of all charges. I don't know what happened to you. I cannot tell you how disappointed I am. I'm going to listen to what we wanted to help you. We got you in sobriety court, and you just, I don't know what happened. I don't have any, I'll listen to what you have to say, Mr. Shemke.
Your Honor, I believe that my client was going through an arduous period of time. She was very sincere and polite during our dialogue. I'd respectfully request any leniency this honorable court could consider when determining an appropriate admonishment. Thank you, Your Honor.
Ma'am, anything you would like to tell me?
Yes, I truly just would like to apologize to you, Mr. McNally. I know you were giving me a chance, and I don't know, I just gave up at that time. I knew I was gonna go to jail for Southfield, and I just felt like giving up, you know? But honestly, since I went to jail with Southfield and went to a treatment program, I truly have been sober this whole time. I haven't been drinking at all. I don't have any desire to even drink.
When did you
I
go to
haven't drank-
Southfield jail? Let me ask you a question. When did you go to jail in Southfield?
It was like May. It was shortly
Last
after those
May?
violations. Yeah, it was
How long
shortly
were you-
after
how
those
long were you-
violations.
How long were you in custody there?
I think I did 10 days in Oakland County, and then I did 30 days at a treatment center in Pontiac. And I think that's where I really got scared too. I thought I probably misunderstood, but I thought Emily said I could bring in my certificate, my sobriety certificate, and it kind of double count and take care of everything here. And when I came in and talked to an attorney, that wasn't the case. And I really just got scared, McNally. I just got scared.
What do you mean when she said you could bring in your certificate? You didn't think that you didn't have to go through sobriety court with us, right?
I don't know. I remember talking to Emily why I was in the treatment center, and she said, bring in your certificate. And I thought she said it would kind of double count and take care of, what I had going on with you guys. So I came in with my certificate, and that's not what the attorney was saying. So I got scared.
Well, I wish you wouldn't have.
I remember her coming in. I know. She did come in, and then she left before she saw you.
Yeah, you were here for a probation violation hearing on July 18 of 24, and then you decided to leave.
Yeah, I got scared. I just got scared. I'm
How
sorry.
much credit does she have? You don't have to apologize to me. I mean, I just wanted to help you, that's all.
I know
And-
you
and
did.
What is the, how many days credit she had coming? Can you tell me, did she? Did she do her court work and community service here?
No.
So she has, and she was taken into custody when, Detective, today?
It was last night, Your Honor. Let's see. At around 9:49 p.m.
Can you come up with anything here?
No, I mean, she pretty much went in, let's see, she got sentenced on January 10th, and yes, she went into warrant status before she accomplished anything. It looks like her court work program days were scheduled for May, but she didn't attend them, and I never received proof of any community service either. And I didn't get, I do think she did go to inpatient, but I never received proof of it when she came in. She left before I got anything.
I hate to do this. I mean, you just don't leave me any choice. I don't have enough time to get you through sobriety court now. I just wish you wouldn't have done this. I was really surprised when you absconded like this, to tell you the truth. Are you working?
Yeah, I just started a second job.
Let me see her screening again, please. I hate to do this. You just don't leave me a choice. You know, if you'd have come in, even when you violated, we realize people are going to have relapses. I would have been very forgiving. You probably wouldn't even have served a day. I don't think you had any other violation. How many other violations did she have besides that test? Oh, she did have 3 or 4 here anyway, but still, I would have worked with you. I would have understood. I would have tried to help you. Where are you working now? Give me both places.
I work at a Quality Inn hotel right now. And Green Farm, I work as a receptionist.
Why did you leave that day when you were here for the show cause? Tell me why you left.
I was just scared. I thought Emily said that my certificate could kind of double count with my warrant with you guys, and when I came in and I talked to the attorney, that wasn't what he was saying, and I just got scared.
I don't want to know what the lawyer was telling you, or you were telling the lawyer, quite honestly. That's confidential. But anyway, go ahead. If you want to say something else, I'm going to listen. But I don't want you to have this. I don't want you.
I'm sorry, McNally. I know you wanted the best for me, and I wish I would have just stayed on track, because in the end, I've been doing good. I haven't been drinking. I should have just stayed right with you guys. You guys put me in the sobriety program. I should have been thankful to have been placed in that, and I should have just stayed on track. But I apologize, Mr. McNally.
You don't have to apologize to me. I just wish you wouldn't have done this. I don't have any choice, really. Probation's revoked. I'm going to do the best I can for you. You're to pay costs of $300 and serve 93 days with credit for 10 for 83. If you pay costs of $300, I'll suspend 43 of the 83, and you'll only have to serve 40. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal if you cannot afford one. I really wish you well, Rachel. I'm really sorry this happened. I would have loved to have helped you. You gotta stay clean, and you just, I don't know what else to tell you. Good luck. Thank you.
Thank you, McNally.
Thank you, Your Honor.
Thank you, Judge.
Zachary T.R. Bogas, 5W705-372. Mr. Bogas, your name, please.
Yeah, Zachary Bogas.
All right, Mr. Winters, how are you? Good morning.
Fantastic. Thank you, Your Honor. For the record, William Winters, P35975 on behalf of Mr. Bogas. Actually, I'm sorry to interrupt. I wonder if I could have a brief breakout room with Mr. Bogas, please.
Sure, we'll put you in a breakout room.
Thank you very much.
No problem. Take your time. Mr. Strong, did you have a chance to meet with Mr. Gardenhire? Are you ready on yours? I don't believe I have the file yet.
Judge, we're ready. It's going to be a waiver.
Okay. Do we have Gardenhire yet?
Yes, right here. I'm right here, sir.
Okay, I'm going to ask you to take your hat off, please, and we're going to get your file, and we're going to take care of you. Okay.
Okay, sounds good.
Attorney, Mr. Anderson, good morning. What do you have?
Morning, Judge. I have Michael Carter Burke. I understand he's in jail, and I would ask for a breakout room with him.
All right. You're not in a moving car, right?
No, I pulled over.
Okay. Okay. You go ahead. We'll put you in a breakout room with them, and then we'll take care of that. Okay. Thank you.
Thank you.
Yeah, and I want Mr. Mohammed in here first, okay? Okay. Well, give me that first, and then as I'm getting through this, you can get Mr. Mohammed in here on Rose. People against Gardenhire, Darius Marcel Gardenhire, 248-720643. Good morning again, Mr. Strong. You're muted, sir.
Yes, Your Honor. Ronnie Strong appearing on behalf of Mr. Gardenhire. Mr. Gardenhire, state your name, sir.
Darius Gardenhire.
All right, Mr. Strong.
Your Honor, at this time, Mr. Gardenhire is going to waive the preliminary examination.
Is that what you want to do, Mr. Gardenhire?
Yes, sir.
All right, you have the right to a preliminary examination on this charge. At that time, the people have to show that the crime was committed of flee and elude fourth degree, and that you were the one who probably committed the crime. Your lawyer tells me you wish to waive that right. If you waive that right, that means you'll automatically be bound over for further proceedings to the circuit court on this charge contained in the complaint, which is a 2-year felony. Do you understand that?
Yes.
You still wish to give up your right to an examination,
Yes.
preliminary exam?
Yes.
Anybody force you to do that?
No.
All right, I'm going to accept the waiver. I find the waiver's been made voluntarily and understandingly. You're bound over for further proceedings to the Wayne County Circuit Court. The AOI date will be on April the 8th, and that will be at 9 o'clock in the morning. Okay. 9 o'clock in the morning on April 8th at the Criminal Justice Center. Bond is 20,000 PR. The prosecutor didn't send anything in. I'm assuming he has no objection to the continuation. I'm sorry, to the bond continuing. So I'm going to go ahead and continue the bond. Bond's continued on this April 8th, 9 o'clock in the morning. Mr. Strong, anything else you need to bring up, sir?
Nothing else by the defense, Your Honor.
Thank you very much. Good luck, sir. Bond's continued. Thank you.
All right, thank you.
Judge. You can sign off, sir.
I need, who's the lawyer on Rose? Is that you or Mr.?
Myself, Your Honor.
No, I know, but I need the prosecutor. Is that you?
That's me.
Daniel Allen Rose, 25F703-213FY. Mr. Rose, your name? Good morning.
Good morning, Your Honor. Mario Lehman on behalf of Mr. Rose. This is date and time set for a preliminary examination.
Ms. Holloway?
Good morning, Your Honor. Nora Alley on behalf of the people.
People can't proceed.
Correct, Your Honor. Defense makes a motion to dismiss.
Where's the complainant?
Your Honor, we sent out subpoenas and the officer in charge was not able to locate the complainant, even though he had advised that he had searched in, I think, about 5 different cities. And at this time, we cannot proceed.
All right, case dismissed, motion of the defense. Sir, I'm gonna go ahead and lift the bond conditions. Do note, however, that this is dismissed without prejudice, so they could initiate this case again. I just want you to understand that. Do you understand that?
Yes, sir.
So change all those bond conditions, take them out if you would, Lisa, please. Thank you. Thanks, counsel. Have a good day.
Thank you, Your Honor. Have a great day.
Too. All right, so when Mr. Winters is out, I'll take his, oh, wait a minute. We're gonna just-
Ready on Burke.
Yeah. Okay, can you tell me he's ready on Burke?
Yes.
How you guys doing out there? Doing all right? Good. All right, Burke. Michael Carter Burke.
Hi, Your Honor.
24I 702893. Good morning, Mr. Burke. Your name?
Michael Carter Burke.
Counsel?
Good morning, James Anderson, P 31302 on behalf of Michael Carter Burke. Your
Okay,
Honor,
so you go ahead. I'm sorry.
I was just going to say that I did speak with the prosecutor this morning and I spoke with Mr. Burke, and the prosecution has graciously offered Mr. Burke the opportunity to plead guilty to the lesser included offense of attempted unlawful use of a motor vehicle, which is a 1-year misdemeanor. I discussed that with my client and he wants to take advantage of that offer. And we also consent to having these matters heard via Zoom.
He's wrote, let me check something here. Give me 1 second, okay?
Sure.
Just want to check one thing. I need to call in, okay. Okay, so if you plead guilty to attempted unlawful use of a motor vehicle, that is a 1-year misdemeanor. It's punishable by up to a year. And in that case, this UDAA charge, the 5-year felony, will be dismissed on motion of the prosecutor. Do you understand that? You have to unmute.
Yes, I do. I
All right,
understand
do
that,
you
sir. Judge.
Tell me your name again, sir.
Michael Carter Burke.
All right, so do you understand if you plead guilty to this charge, attempted unlawful use of a motor vehicle, that's punishable by up to a year, and you are giving up certain rights. You're waiving your right to call in the prosecutor. You're waiving your right to remain silent. You're waiving your right to have a jury trial of any kind. You're waiving your right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses, 249. If you plead guilty, you'll be giving up all those rights. You'll be waiving your constitutional right to a jury trial and waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand that?
Yes, I do.
And is this still how you wish to proceed?
Yes, sir. Yes, Judge.
All right. To the charge attempted unlawful use of a motor vehicle, how do you wish to plead?
Guilty of taking the car without authorization.
Okay, hang on.
Right?
Your name?
Good morning, Your Honor. Mohammed on behalf of the people.
So I'm just going to take the factual basis, but I want to inquire about something here. Did you in fact take without permission and use a 2012 Chevy Equinox that belonged to one Diane Burke that was owned by her?
Yes. Yes, I
And
took
you
my
took
mom's
that without
car.
her permission?
Yes,
You
yes.
took that without her.
I've done it before. I
Listen,
brought it
let
home
me-
a bunch. but-
wait. Let me finish my question. Did you take that without her permission and drive the car?
Yes, I did.
Are you on probation or parole right now?
No, sir. No.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No.
You wrote down here, Mr. Muhammad, a 2-year misdemeanor.
So Judge, that the MCL that I wrote it under is originally it's a high court misdemeanor, which makes it a 2-year misdemeanor. But at the end of that plea, I wrote attempt, which reduces it to a 1-year
I
misdemeanor.
just wanted to make sure, because you wrote 2-year, I get it. You wrote 2-year misdemeanor attempt, I get it. But
because it is a 2-year. So I wanted you to be aware that
the charge is a 2-year, but the attempt is a 1-year.
Exactly.
Right.
I
Okay.
wanted
Just the way you wrote it, I thought you were saying it's a 2-year.
And
I
they
can't,
have
I don't
two
have.
of them. They have one that's like a 90-day.
I know.
I just wanted you to be aware.
So I'm going to accept your plea to attempted unlawful use of a motor vehicle. I'm going to dismiss the UDAA. We're going to do a pre-sentence report on him, and I'm going to sentence him at a later time, Mr. Anderson. What is a good day for you, counsel? Can you be here? How do we look on the 8th or 15th, Lisa? It doesn't matter to me.
We can do the 8th at 8:30.
Are you good that day, Mr. Anderson?
Let me check right quick. The 8th at 8:30.
Yes. And believe it or not, if somebody's here, I'll be on the bench at 8:30.
Oh, well, in that case, yes, Judge.
April 8th at 8:30. Good. Sounds good. We're going to do a pre-sentence investigation on you, and we'll go from there, and we'll see everybody on April the 8th, okay?
Your Honor,
Anything else?
may I address bond in this case?
You can, and I'm going to listen to Mr. Mohammed too, but I do want you to be aware, I believe he had multiple warrants, which is why these guys just don't help themselves when they pull this nonsense. 3, 4. I mean, he's got 10, 11. He's got at least 11 warrants, 13, 14. He's got 21 warrants or thereabouts. I mean, that's the problem.
Judge, if I can just put on the record that the OIC in this case is the chief of police, and he was here present today, and he's actually brought up the idea of this resolution. So I just want to place on the record, he gave approval and he came and spoke to me and brought it to my attention, which is why we extended a plea offer.
I don't need that explanation.
I know.
I just want to know why I can give a personal bond on somebody that doesn't show up. He's got 25 warrants. Go ahead, Mr. Anderson. I won't interrupt you again.
Well, the main reason is he does have a number of real estate matters that he needs to attend to, but more importantly than that, he does need to address these outstanding warrants. I don't know if there are holds on him for those warrants, but if the court would consider a personal bond on this and see to it that he can't be released until those warrants are handled, I believe that would be reasonable, or at least that he be arraigned and at least arranged to have court dates on those warrants.
Where do you live at, Mr. Burke?
I live in the condo. My mom passed away, and I just inherited the condo. I live in Grosse Ile. I got a bunch of real estate matters I'm attending to, a bunch of properties my mom left.
Settle down. Just let me ask you a question, okay? Do you live at 8187 Grays Drive apartment? It looks like building 8.
Yes, I do.
All right, now look. You're being silly. How old are you?
I'm 49.
How old are you? Aren't you getting tired of this? Aren't you getting tired of running from the police?
Absolutely.
Okay, I'll tell you what. I'm going to let you out. I shouldn't let you out because this history of yours tells me there's no way you're. Listen, it tells me you're not showing up. Now, but I'm going to remember you, Mr. Rose, or Mr. Burke, because I'm going to remember that I went way out of my way. And I'm doing it in part because you live on Grosse Ile. And I'm going to call the chief or whoever else over there, not the chief, if he somehow was a victim here. Is that what you said?
No, Judge, the chief of police was just the officer in charge of the case.
Okay.
So he was present here today.
All right. Well, I'm just saying to you, I'll reduce this. I'll make it a PR bond, same bond conditions. You cannot leave the state without consent. You can't violate a law. Now, I want to be clear about this. Just let me ask a question here. I want to make sure. No contact with Diane Burke or prosecution witnesses. Did they ever print you on this case? Let me see here.
Your Honor, sorry to interrupt, but Diane Burke is Mr. Burke's mother, and sorrowfully, she's passed away, Your Honor.
Oh, I'm sorry. I'm sorry. You did say that. Did you ever go over and get printed on this case? You did not. I'm going to order that you go over and get printed. I'm going to just write down here. Judge Kirsten ordered you to get printed. You didn't get printed by Grosjean. Lisa, is this right?
I got
this
printed.
Was done March.
I got a messed up finger and they couldn't get the little finger to take a print for some reason. But I did get printed. It's just my finger, I cut it when I was 18 years old by a fool.
Well, maybe they can, I don't know what to tell you. Hang on a second. Lisa, this lien that I have is dated the 12th. It looks like Judge Kirsten took the plea on the 12th. So he signed an order.
I can check into it, Judge. Maybe he can just stop in and see me when he comes to the court for screening.
I want you to come over to the court as soon as you're released, and you're going to undergo a pre-sentence report, okay?
Okay.
And then we're going to give you an order. Lisa, will you flag this and make sure if he's, I'll tell you what, it sounds like he wasn't printed, so I'm filling out a sheet here. I'm going to order you to go over there and get printed at the Grosjean Police Department, and that will be by March 26th at 1. Now listen, if you're in custody on some of these other holds, that's fine. But otherwise you have to be there tomorrow by 1 p.m. And if you're still in custody, the day you get out of jail, you have to go over to Grosjean. Do you understand that?
Yes, I do.
Okay, so that's a condition of your bond. You understand that?
Yes, I do.
All right. All right, so that's how I'll handle it, counsel, and we will see you guys here on April the 8th. And yes, I will give you a personal bond, but I don't want to threaten you, but I'm telling you, if you don't show up, I'm calling over there. I'm going to have you arrested, and you're not going to like at all what I'm going to do then, okay?
Understandable.
All right, best of luck to you, sir. Let's get your life in order, though, please. Thanks, Mr. Anderson.
Thank you, Your Honor.
Thank you, Anderson.
And Judge, just so you're aware, not on this case, but on the Mirabella exam, we're ready to go whenever the court is.
Thank you. John Patrick Geftos, 25W704775. Where's Mr. Geftos?
It's on Zoom, Your Honor.
Why didn't he show up? Is this a trial?
Judge, he's here.
Not a pre-trial, Your Honor.
He's here in the building, or he's there? You are. Your name's. Wait a minute. No, he's not there.
Hello?
Mr. Geftos, your name?
Yes, sir. Johnny Geftos.
Michael A. Carmen, P73824, on behalf of the defendant, Your Honor.
I don't know what they want me to do. I didn't order the victim to appear. They should move the Nolly process. I have no issue. It says the complaining witness failed to appear despite being informed by BA over phone, victim's advocate. So he's going to either have to move to dismiss this, and that's fine if that's what he wants to do.
Your Honor, the prosecutor asked me to make the motion. So based on that, I moved to dismiss.
I didn't order anybody to do anything. If I ordered somebody to appear and they didn't show up, look, this is all nonsense anyways. They should just be moving to dismiss these.
I'm with you, Your Honor.
That's what I'm telling him to do. If he doesn't want to do it, I'm setting it for a trial. I'm completely good with what he's doing here, but I didn't order anybody to appear. If I did, I'd have made a note about it. And if he subpoenaed them on his own volition and the victim didn't show, he has every right to not move to Nolly process. I don't know why. I think somebody's keeping stats somewhere and they worry about that nonsensical garbage, but I'm not going to do that listen, your name?
Good morning, Your Honor. Mohammed on behalf
If you subpoenaed the victim and the victim did not appear,
Yeah.
it's up to you to move to dismiss. I'm not entertaining his motion to dismiss. You guys want to put me in that position, and really the simple thing, I've been telling everybody this for years, and depends on the prosecutor. Prosecutor should be moving to dismiss, not the judge. I'm not
asking for the court to dismiss.
Well, what do you want me to do then?
Well, my understanding is defense would be motioning for a
Well, I'm not dismissing it. On what basis? On what basis?
that we have a stipulation that the complaining witness was supposed to be present today.
Where is that? Did I order that? I didn't make a note of it.
It was on the previous. It was on the form for this last hearing. There's a stipulation between both parties that indicated that complaining witness must appear and be present.
I didn't write it down.
And I have it in my notes, and because what I have in my notes is subpoenas being sent out, and it was based on that.
I get it. I just don't understand this. It's not the way I did business. The office should be dismissing these if they want to dismiss.
Okay, I'll no lay process in the interest of justice.
Case dismissed. Motion to
process. Okay, sir, I'm speaking, please.
No, I'm
and
sorry.
Just for the record.
Sorry.
Just for the record, the complaining witness was subpoenaed to be present. The victim, I want to put it on the record.
Go ahead. I read it. No problem.
And, did you read it onto the record?
I didn't read it. I just noticed that you have a stip form complaining witness failed to appear despite being subpoenaed. I did not remember or didn't make a note that I was ordering the victim to appear. And you said complaining witness failed to appear despite being informed by victim advocate over phone.
Yes, the victim advocate had contact with the complaining witness, informed him of today's hearing, and he still failed.
So I'm going to go ahead and dismiss the case and not your motion. Thank you. Thank you. Lisa, cancel all the bond conditions on that. Mr. Geftos, you were all set.
I promise this will never happen again.
Good luck. Don't say anything against your interest here. Zachary T.R. Bogas, 25W705372. All right. Everybody's name on this. Mr. Winters, good morning. Your name?
Good morning, Honor. William Winters, P25975 on behalf of Mr. Bogas.
Mr. Bogas, your name?
Zachary Bogas.
Detective, your name? All right, so what are we doing on this one, Mr. Winters? Is this just proceeding to exam?
Yes, Your Honor. I believe we have a date already selected, if that's convenient with the court.
Yeah. For April the 1st we're doing, right?
Yeah.
Preliminary exam will go on November, I'm sorry, April the 1st. I think I have it at 11:30. Is that still good, Lisa?
Yes, it is.
Okay, 11:30 next week. Have a good day, Mr. Winters. Good luck, Mr. Bogas. We'll see you here then. Thanks, Detective.
Thank you very much, Your Honor. I do have one other matter before the court, but I'll go back in the queue, as they say. Thank you.
Okay. All right. Thanks.
Winters, you need to speak to that client.
Mr. Kyles?
Yes.
He may be present in the courthouse.
Okay, I show him on Zoom, so I can put you in.
Oh, that's even better then. That's even better. Thank you very much, Lisa. If I can get a breakout room, that would be great.
Yep, I'll move you right now.
Do I have anything else or no right now? Okay. What case are you guys waiting here on?
Mirabella.
Okay.
I haven't seen her train dock yet.
Okay. 11:05. What am I doing on this? Okay. Let's take a break. Stay seated. You guys are good. Stay there. We're good. All right. Stay seated. Court's back in session. Got anything? Morning, Mr. Collins.
Good morning to you, Judge.
What case do you have ready for me?
I have Venisha Bell.
Okay. All right. What are we doing on that one? Is that going or is it a waiver?
Judge, we're asking for a 1 week adjournment. The prosecutors made me an offer. I want to talk to her about it.
You know, I like adjournments, right?
I know, Judge.
People against Venisha Bell, Venisha Renee Bell, 24M710670. Your name?
Venisha Bell.
Judge, for the record, Harold Collins, P56805 on behalf of Ms. Bell.
I got to get my cases done. I'm ending the state docket.
Yes.
I mean, can't we just keep this on for next week? And if you guys decide to plea, you can plea.
Oh yeah, Judge, we have that date. Yeah, we're all set then. Yeah, I want to talk to Ms. Bell about where we're at, and we'll come back on that date.
All right, so April 1, we're going to exam though. You understand that?
Yes, Judge. Yeah, if we don't have a
And
deal.
listen, if you guys decide to take the deal and you want to log in at 8:30, that'd be preferable, or 9 o'clock. And I'll take the plea if that's what you guys decide to do. If not, then you'll be here at 1 o'clock. I've got a note here saying you were not printed. Did you go over and get printed, Bam?
I didn't know I was supposed to get printed.
I ordered you to do that last time. I said you had to go to the Taylor Police Post.
I don't know where that got mixed up because I didn't know.
Counsel, I don't know if you guys want to call over there, but she needs to go over there today or tomorrow. Okay? What day did I sign that order, Lisa? Do you know? I didn't date it for some reason.
I can check. Hold on. I believe it was March 4th.
You got to go over there. You can't just ignore an order like that. Come on. I mean, these aren't my rules.
Judge, there was
Yeah.
one, wasn't there one last week or the week before that you forgot? Remember you said I forgot to tell the attorney? That might have been the one.
This was 3 weeks ago.
Right. I don't recall hearing that information, Judge, on Ms. Bell.
I'll just refax it.
Okay.
All right, you have to go over there today, but you can call the state police post today. They don't always print every day, so you just make sure you call there and you're either going to go over there today or tomorrow and get printed, okay?
Sounds good. Thank you.
All right, good luck. Thanks, Mr. Collins. We'll see you next week.
Okay, I'll be in touch, Ms. Bell, so we can discuss this matter.
Thank you.
Brent Early. Brent Keith Early, 25T708726.
Good morning, Your Honor. Paul Tefelsky, P52844 on behalf of Mr. Early. Your Honor, this was the date and time set for the exam. My client contacted me this morning about 8 a.m. and he was very ill. I told him to go to the hospital or go to the urgent care. He did reach back out to me about an hour ago and say he was in a bed at the hospital, had been taken by ambulance to Trenton, some kind of food poisoning or stuff.
Did you talk to the prosecutor about this?
I talked to the prosecutor.
What did he say?
And we discussed the possible resolution of the case, and I think there's a very good chance we'll resolve it. So he asked to adjourn it to a PCC and not to another exam that he thinks we will.
Call in the prosecutor, will you? 249, Will. I've had this adjourned a lot, though. I mean, I got to move. Yeah.
Today was the first day we were set for exam, Your Honor.
Well, I know, but he was arraigned February 27th. We had it set for March 11th and March 18th, and then that was adjourned a week.
I think
one of those, and now it's March 18th and March 25. Now you want me to adjourn to 4-1 and 4-8.
I think, Judge, I can tell you though that we're either going to resolve it or we'll waive it. I don't. Having talked to the OIC and the prosecutor, I'm comfortable with telling.
Mr. Mohammed, your name?
Good morning, Your Honor. Mohammed on behalf of the people.
So you've extended an offer.
Correct. So currently the offer is as charged to count 2.
I don't need to know what the offer is. I
Okay.
really don't.
Which,
And you're confident he's up?
I'm confident. I could tell talking to him that he was.
I'll
driving.
adjourn the PCC to April 1 and we'll make this at 9 o'clock in the morning and then the exam April the 8th at 10:30. Now, if he's not gonna, pardon?
I was just gonna say, Judge, just for the record, the OIC approved the plea.
Oh.
I know, just for the record, I have to put it on the record.
Who told you to put that on the record?
It's just some advice I've gotten.
From who? I don't want you to tell me.
Lawyers.
Oh, boy.
Judge, April 1st.
What other lawyers are giving you advice to put on the record that the OIC approved the plea?
Some prosecutors.
Well, what?
Do you want me to name?
No, I don't want you to name them, but the OIC shouldn't have that much to do with
It's just
approving.
someone we consult with and make sure that they're on board. It is
Okay, all right. Well,
something-
that's up to you guys. You just go ahead. What do you want now? I'm sorry.
Did you say 9:30 on April 1st?
April 1st at 9
9.
and April 8th at 10:30.
Oh, and Judge, for the PCC, can we appear by Zoom for that? On the 1st?
Yes.
Thank you so much. Thank you.
You're not gonna be driving though, right? You're not gonna be in a car.
Thank you.
Have a good day. Tyarius Bryant. 2-4B-716-3361. Mr. Carmen, your appearance?
Michael A. Carmen, P73824 on behalf of the defendant.
Bryant, your name?
Tyarius Bryant.
All right, so he is going to do what? We have 2 counts. He's going to plead to count 2, B&E a vehicle to steal property less than 200, which is a 93-day misdemeanor. Oh, no, he's going to plead to count 1, which is a 1-year misdemeanor, and count 2 will be dismissed, right?
Yes, Your Honor.
Is that what you want to do?
Yes, Your Honor.
If you plead to count 1, the possible penalties are up to 1 year in jail, 2,000 in fines, or 3 times the value of the property stolen, whichever is more. If you plead guilty, you're giving up your right to a trial by court or trial by jury. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Again, you're waiving your constitutional right to a jury trial. If you plead guilty, you're giving up all those rights. You're waiving the presumption of innocence, as I said, and you're waiving your right to remain silent. We will not have a trial of any kind. Do you understand that?
Yes, Your Honor.
All right. To the charge of B&E of vehicles to steal property, 200 or more but less than 1,000, how do you plead?
Guilty.
Were you at 18110 Pine East in Brownstown, June 19 of 23?
Yes.
And what did you do? Did you go into a car?
I went into a car and I took a pair of gym shoes, Your Honor.
And you stipulate that the value of those exceeded $200, Mr. Carmen?
Yes.
Stipulated.
I'm sorry, I didn't hear you.
So stipulated, Your Honor.
And you didn't have permission to enter that vehicle or take those shoes, correct?
Correct, Your Honor.
Did you know the person who owned that car?
No, Your Honor.
All right, it was a Chevy Traverse. Is that true?
Yes, Your Honor.
Are you on probation or parole right now?
No, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Okay, I'm gonna accept your guilty plea to count 1. It's a 1-year misdemeanor, B&E to steal property 200 or more, but less than 1,000, breaking and entering a vehicle, 200 or more, but less than 1,000. Count 2, less than $200, the 93-day misdemeanor is dismissed. You're gonna have to come over here. I'm gonna let you call probation and figure out when they're gonna have you come in and do a pre-sentence report. So I'm gonna order a pre-sentence report. So you can call this number if you have a pen there, 734.
Hold on, Your Honor. I'm getting it up right now.
671-0201, extension 245. You can tell him Judge McNally wanted me to call and see when I can come in and do my PSI. Same bond conditions, no contact with Timberly Dennis, Pearl Lee, Joseph Matthews, no contact with prosecution witnesses. You're not to enter 18110 Pine East in Brownstown. You cannot leave the state without consent or violate a law, and you must appear in court as directed. Lisa, what date are we going to do this on?
April 8th at 9.
April the 8th at 9 will be your court date. Okay, sir?
Okay, and that is for what, Your Honor?
What's that? You weren't just vaping or something, were you?
No, no. This is a straw.
Okay.
I'm
Which?
sorry, Your Honor. I didn't mean
That's
to
all
have
right.
it
That's
that
all
way.
right. That's all right. That's
I
all
don't
right.
vape though.
Fine. I want to know what your question was. You asked me a question and I didn't quite hear you.
My question was, what is the court date on the 8th?
April 8th at 9 o'clock in the morning. You have to appear in person, okay?
Okay, and that is where at?
33rd District Court in Woodhaven on Van Horn and Allen. We're on Van Horn. And you need to call over here to probation as soon as you hang up to make sure that you figure out what day they want you to come in to do the pre-sentence report, okay?
Okay, but my other lawyer, I was told that I have probation with felony court downtown on the 8th.
Oh, yes. Wait a minute, I didn't order that on the 8th, did I? Didn't I order you to go? You're out of custody, so I ordered you to go to, I'm gonna need that file, to arraignment on the information on the 1st, didn't I?
Yes.
Well, you got another case going on too downtown?
No, this is for because you know I had 3 charges, the 2 B&Es and the felony charge.
But she had a felony this morning. Oh, the
Yeah, I know, I thought-
bind over date was the 8th.
Oh, that's right, because he's out of custody.
Yeah,
We'll make it another, we'll go the 15th, right?
8:30, 15th at 8:30.
The 15th at 8:30?
Yes, but you have to get a hold of probation and make sure that you get over here and get your pre-sentence report in the next couple days. That's why you're gonna call that number, okay?
Okay, Your Honor.
Best of luck to you. I wish you well. Thank you.
Hold on, wait, one more thing, Your Honor. I don't want to be confused. So do I have court on the 1st or the 8th or the 15th? I really don't know.
On this case, the one I just called, you're coming back here on the 15th we gave him, right, Lisa?
That's correct. The 15th at 8:30 on this case.
On this case, you're going over to Detroit on April the 8th and you're calling the court here and making sure you get over and get your pre-sentence report in the next couple days, okay?
Okay.
All right. Do we understand all that?
Yes, Your Honor. You all have a nice day.
You too. Good luck.
Thank you.
Thank you.
All right, let me see here. All right. People against John Dutton Jr., 25T7030059. Mr. Dutton, your name?
John Dutton Jr.
Ms. Carmen?
Michael Burke. He's 73824 on behalf of the defendant, Your Honor.
Who wrote this up?
So Judge,
your name?
Good morning, Your Honor. Mohammed on behalf of the people.
So when you write minimum 18 months probation, it makes it sound like it's a sentence agreement.
So Judge, in this case, I understand the court isn't normally inclined to accept sentence agreements, but in this specific case, it did go through the chain of command at my office, and that plea form was written up by a supervisor. and it was based off of the understanding that it would be a sentence agreement. And so I would respectfully request the
They
court.
want us to take them in our sobriety court. They're putting that in, and I
Yeah,
don't even know
so-
anything about this. I mean, what?
So there was my understanding based off of.
I'm not doing a sentence agreement on a sobriety court case for this reason. If he goes through the bond phase and he doesn't make it, if it's a sentence agreement, I have to let him withdraw his plea if we don't take him in. So I don't know why they feel like they have to do that on misdemeanors. If
So
they don't think we're hard enough, or we're too hard, or not hard enough.
No, it's not that, Judge.
Well, what is it? I mean,
So my understanding is because the defendant is a habitual offender, there is just a chain of command from our office, and there's special guidelines that.
Was the officer hurt in this case?
I don't believe so.
Your Honor. Next, Sergeant Marcus.
Come on up here.
Sorry, Your Honor.
You're fine.
Morning, Your Honor.
Good morning.
Sergeant Mark Driscoll, Trent Police. No, the officer was not injured in this.
What happened?
So they responded to Mr. Dutton. The allegations are Mr. Dutton called 911, requested to go to jail that evening. Another phone call followed that when officers responded to kind of take care of him. He was highly intoxicated. At that point, he made a conversation that he wanted to go to jail. They told him he committed a crime. He subsequently steps off the porch and swings at one of our road sergeants.
He's got armed robbery convictions and everything. I don't.
Again, Judge, the defense made a request. It went to my supervisor. The supervisor responded with the plea that you have in front of you.
Would you call Beth in? Violation of terms resulting in jail. I hate when they do that. They're not going to tell me what to do on a probation violation. If they want to determine what happens to defendants when they violate probation, they're in the wrong profession. They need to be a judge. I'm not doing that. And then they include these other terms here that say if there's police contact. What if he pulls them over for expired license? And the guy comes in and pleads guilty to expired license. I've tried to tell people this for decades. I'm not going to be a party to having some prosecutor here, there, or anywhere else tell me what I'm going to do. They're not going to do that. They're not going to do. I don't know how many times I have to say it.
I understand.
Well, you don't understand because they keep doing it. Apparently they don't understand. I've had conversations with them. I am not about to box myself into a corner where somebody's stipulated agreement written in small print is going to put me in a position where I have to send somebody to jail that I don't think deserves jail. Now, maybe he does outright. I don't know. I don't know enough about the case, but not this no police contact. So he has an improper plate. That's a misdemeanor. He doesn't have his license on his person. That's a misdemeanor. And they want to tell me I got to send the guy to jail. Your name, please.
Elizabeth Osprey.
I want to ask a question because I remember we couldn't even take a domestic violence defendant into sobriety court. And they've relaxed that rule. But violent felonies, correct? We cannot put them in sobriety court. Am I right or wrong about that?
You are correct, Your Honor. They are actually leaving it up to the discretion of the judge.
I'm not taking,
and
so somebody should have known, I'm not taking armed robbery defendants into sobriety court. I'm not doing it.
There's no charge of armed robbery here, Your Honor.
He had an armed robbery conviction. Listen to me.
15 years
ago. I know
ago.
It was a long time. I don't care. He's got an assault with intent to rob while armed in 09. He's got a.
Yeah, I should mention.
You don't interrupt me. In 09, he's got an armed robbery conviction and felony firearm in 09. He's got a retail fraud in 24. He's got a 25 impaired. Now, look. Off violation of items, terms resulting in jail. No, I'm not taking it.
So Judge,
You can go back and tell them again. They're not going to tell me what to do on a probation violation. I don't know what the probation violation is. If he beats up his mother, he's probably going to jail. If he's driving around without a valid license or doesn't have a license on his person or has an expired license, I'm not sending him to jail.
I understand.
No print amount of print that they're going to put in here is going to tell me to do it.
I understand.
Yeah, I know,
We
but
can.
it gets frustrating when I tell people this 100 times. And I still keep getting them. They change prosecutors and I get the same plea agreements. You're all set. I don't know that I won't, but they're going to have to work on their terms.
Can we amend it and to committing no crimes instead?
I'm not going to, I have told your office multiple times how I feel about this. I'm not getting into doing that now. You could take it back to them and tell them what I said. They're not going to tell me what to do in a probation violation. Ever.
I understand.
They're not. I mean, I've said to Mr. Bresnahan and others, do you tell circuit judges what they're going to do when there's a probation? I mean, does your plea agreement set forth what's going to happen in the event of a probation violation? I don't think so. And they're not going to hamstring me by saying sobriety court, but if he commits a crime, which can include, like I said, no ops, you have to send him to jail for the balance. That's what I was getting. This one doesn't specify how long. Look, I take this seriously. And when I get a stipulated plea agreement, I'm not going to say yes and then do something different. I'm not. So you guys can go back to the drawing table. If they feel that uncomfortable about this, then send him to circuit court.
Honor,
He can go, he can, hang on. Don't interrupt me, Mr. Carmen. He can go up to circuit court. They complete him to a 1-year misdemeanor there. And he can do all those things. They can put him on there. And if there's a circuit court judge that has no problem with it, God bless him. I got to go home and sleep. I'm not going to let people tell me what to do, period. And I've had this the last discussion I'm going to have with your office. Last one. Don't send me garbage telling me what I'm going to do on a probation violation again. I'm telling you. Go ahead and smile. It would be funny if I hadn't had to have this conversation at least 48 times.
No, I understand.
Okay. Well, I know. I've had it with every prosecutor that's been in here since in the last 15 years, it seems like, and they keep sending it back to me. So I'm adjourning this 1 week, and you guys are going to figure it out. And if it isn't resolved, I'm not taking it, Mr. Carmen. No. I'm not taking it. I'm not having people tell me what to do. That's not their function.
I was going to ask if we could just waive him and bind him over now in the case, and we'll.
Whatever you guys want to do. You want to do it, do it. I could care less. I could care less. Is that what you want to do?
Yes, please.
Where's that file? All right. Mr. Dutton, your lawyer tells me you wish to waive your right to a preliminary examination on this charge. Is that true?
That's correct, Your Honor.
If you waive your right to an exam, you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, Your Honor.
Is that how you wish to proceed?
Yes, Your Honor.
All right. So you understand by waiving your right to an exam, you're waiving the requirement that the people show that the crime was committed and that you were the one who automatically committed, you were the one who committed the crime, and you'll then be sent to Detroit, correct?
Yes, Your Honor.
All right, waivers accepted. You're bound over for further proceedings. You're out of custody. It was a $10,000 personal bond. April the 8th. I'm sorry, April, yes, April the 8th. Where's the bind over certificate? You see it? Mr.
Your Honor, would that be
AOI
for
date
April
will be
1st? A week from
April
today?
the 8th. No, it's going to be 2 weeks since he's out of custody. April 8th, and bond set in the amount of 10,000 PR. No objection to continuation of bond, counsel?
No objection.
All right, so that'll be the date. Good luck to you, sir. People against
Thank you, Your Honor.
Alice Knight. Joanne Teresa Alice Knight, 24T 705-654. What are we doing on this one?
Good morning, Your Honor. Just presenting for behalf of my client. This time, we're going to be waiving the preliminary.
Is that what you want to do, ma'am?
Yes,
Your name?
Joanne Teresa.
All right, you have the right to a preliminary examination on the charge contained in the complaint and warrant. By waiving your right to an exam, you're waiving the requirement that is to each count, the people have to show that the crime was committed and that you were the one who probably committed the crime. If they prove that, you'll be bound over for further proceedings to the circuit court. If they fail to prove that, the case would be dismissed and you would be discharged. Do you understand that?
Yes.
But by waiving your right to an exam, you're waiving that requirement, and I'm going to send you to the circuit court for further proceedings. Do you understand that?
Yes, I do.
Anybody force you to give up your right to an exam?
No, Your Honor.
You still wish to do that?
Yes.
Waivers accepted. PR bond of 10,000 is continued with the same bond conditions, and April 8th at 9 will be the court date. Anything else?
No, Your Honor.
Thank you.
Thank you, Your Honor.
Andre Gaetano Mirabella, 24B 709-735. Mr. Dox?
Good afternoon, Your Honor.
Good afternoon.
Attorney Dox, P number 79657, on behalf of my client, Mr. Mirabella.
Mr. Mirabella, your name?
My name is Andre Gaetano Mirabella.
All right, let's do this one. Was he ever printed?
Yes, I'm printed on record.
I can't hear you.
I'm printed on record, sir. I've been printed before.
You got to get printed on this case.
Oh, I don't know about this one specifically.
Well, you got to get printed on this case. Judge Hessen ordered you get printed on. Has he been in custody? Is that what's happening?
Yes, Your Honor, he's at the NTU.
I see. Okay, I'll worry about that after. This is going to exam, right?
Yes, Your Honor, my former client's right, it was statutory right to, he's going to waive his exam.
Oh, I'm sorry. My mistake. I'm sorry, counsel. I thought he was going to exam. You have the statutory right to a preliminary examination. Do you understand that?
Yes, sir.
At that examination, the people would have to show that the crimes were committed and the crime was committed, and you were the one who probably committed the crime. By waiving your right to an exam, you'll automatically be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, I do.
You still wish to give up your right to an exam? Anybody force you to do that?
No.
I'll accept the waiver.
Thank you, Your Honor.
And we will send him, I'm gonna need Brownstown. Sergeant Morrison, you guys aren't here on this case, are you?
Yes.
I gotta get him printed.
Okay, you're
Sergeant
up.
Morrison, can you state your name?
Sergeant Morrison, Brownstown Police.
How can we get him printed? I've got some gentlemen here from the Michigan Department of Corrections that brought him over from where? Ionia. So I got to get him printed. Is there a way you can coordinate with them? Can you take them to Brownstown, let them print them first, gentlemen?
Yes, sir.
That's what I'm going to order happen.
That's fine, Your Honor.
Okay. All right, so you're going to go over there and get printed. That's a condition of your bond, obviously. And I'm going to give you a new date, counsel. It's going to be April 1
Yes, Your Honor.
at 9:00 a.m. And we'll go from there. Is there anything else, Mr. Dox?
No, Your Honor. Thank you to you and your court.
Thank you. Nice,
Nice seeing you.
nice tie there.
Thank you, sir. Okay.
All right. Thanks, guys. Sorry to keep you waiting. Thank Thanks, Mr. Winters. Do you have one ready for me?
Yes, Your Honor.
Okay. How's things for Mr. Winters?
Could not be any better, Judge. How about you?
Well, good, except for one little thing, but other than that, it's okay. Everything's good. How about you?
That's, every day that I'm on this side of the earth, Judge, is a blessing.
I know.
We go back
I know.
a ways.
42 years, right?
I think you're right. That's the class of 1983.
That's incredible.
CL history.
If we don't mind saying, right?
That's right.
I'm going to get, do you have Mr. Winters?
I don't have.
What case do you have again, this one?
I have Mr. Kyles, who's actually present in the courthouse. We'd like to waive our exam so he can sign the waiver form and put whatever we need to put on the record.
Are you Mr. Kyles?
Yes, sir.
Talk to the.
Okay.
Hi, Mr. Winters is here and his client's in the courtroom and they want to waive the exam on Kyles.
Judge, I believe my docket is on Kyles. I think it's PPK, correct?
What's the charge on that?
Failure to register.
Oh, it's a sex offender registration case, Mr.
Okay, I'll step in. I'll just show up and take a look.
You got to bring in the file then, okay? Thanks.
Sure.
Are you keeping busy? How's that new building?
Well, it's got advantages and disadvantages. It beats Frank Murphy, frankly, even though everybody had a sentimental attachment to it. Elevators
Right.
work in the new building, drinking fountains, restrooms, everything's pretty good.
Something going on over there.
Well, that's good. I got to go down there and see it one day.
You'll have to come down as a visiting judge.
No, those days are done. I offered to come down and sit on some civil cases, and so did other judges, and it never materialized. I'm not blaming anybody, but they say they need help, and then we offer help, and then they don't want to use us. I don't know. So. And you've had a chance to talk to Mr. Lyles, right?
Yes, Your Honor.
Okay. All right, people against
Mr.
Kyles, I mean. This is Kyles.
Isn't written up yet, Judge.
Okay. I'm going to start anyway. He hasn't written up the stip form. Lesean Anthony Kyles, 24B728085. Are you Mr. Kyles? You can come on up. You can come on up here, sir.
William Winters, Your Honor, P35975 on behalf of Mr. Kyles.
Mr. Kyles, your name?
Lesean Anthony Kyles.
All right, so your lawyer tells me you wish to waive your right to an exam. Is that true?
Yes, sir.
And you understand if you waive your right to an exam that you're going to be bound over on all these failure report, sex offender statutes. You got 9 counts, each of which is a 2-year high court misdemeanor. And you'll be bound over, and you're waiving the requirement that the people show that those crimes were committed and that you were the one who probably committed the crimes. Do you understand that?
Yes, sir.
Is that how you wish to proceed, though?
Yes, sir.
All right. Anybody force you to give up your right to an exam?
No.
All right. I'm going to accept the waiver. I find the waiver has been made voluntarily and understandingly. The bond is continued to 15,000 PR, and I'm going to go ahead and set this for arraignment on the information. You're not in custody, so it's going to be April the 8th at 9 o'clock. And that will be in the Criminal Justice Center on the charges contained in the complaint. And I'm gonna go ahead and continue the $15,000 bond. Prosecutor indicates on here he has no objection, so I'll continue that bond. And you're all set. Anything else, Mr. Winters?
No, Your Honor. Thank you very much.
Have a great day. Good to see you. Good luck, sir. Go down the hall and get your notice. Thank you.
Thank you.
Talk soon.
Thanks.
Done?
We're done.
All right.
Don't send me those anymore.
All right, I will relay it to.
It's not like.
I understand your position.